Welcome to Case by Case. This is a podcast brought to you by Luke Sadkovich and Calum Chain from ZFZ. How are you, Calum?
I'm good, Luke. I'm good. We are getting back into the swing of things.
Kind of in the area of Section 44 again, but completely different take on it. And we're getting into the world of litigation funding and talking about quite a hot topic today. But yeah, before we do it, how's things otherwise? Anything going on in your neck of the woods of interest?
Things are good. It's been a busy couple of weeks. There's been a bit of splashback at the time of recording this from some of the detentions that have been happening in the Red Sea, kind of in this bizarre world of shipping where it's almost kind of state-sanctioned vessel seizures, which really is an unusual situation and a highly uncertain one for market participants. So there's been a few inquiries around whether ships can trade through the Red Sea, whether or not owners can go through a different take a different route against chartered instructions. All those interesting things, and it reminds you how closely connected that world of trade and shipping is to current affairs and the events that are taking place in the world around us.
Yeah, well, it's one of the great things about our practice, isn't it? That we're often dealing with real life events that are happening, whether it's out there on the ocean or in the banks or in the supply chains or you name it. A lot of what we do on that high-profile, complex side of things is dealing with real-life events and the consequences of those. And it's what I enjoy, actually, about the practice and dealing with the high-stakes arbitration litigation work that you and I both get involved in.
Just trying to keep to a diet before Christmas parties ruin everything.
Well, actually, yeah, we haven't spoken about this, but I'm on a promise starting as of yesterday, not to drink alcohol through until Christmas time. So we'll see how that goes. It was bang on a month. And as you know, December's usually a busy time for seeing people and all of that stuff. So wish me luck. But yeah, I'm on a bit of a health kick. Actually, I'm on a bit of an overall personal growth kind of week this week. I'm heading off to Texas tomorrow for a couple of days to attend a conference for kind of entrepreneurs, looking at where their priorities are and how to get the most out of things and to refocus and all of this fun stuff. So wish me luck on that.
Yeah, exactly. I'll be interested to hear how that goes.
Yeah, me too. I've kind of signed up for it. I'm not entirely sure what to expect, so we'll see. You might find a new guy on Monday when we record our next one.
Exactly.
So today we are getting into the world of litigation funding, and I think it's fair to say that the litigation funding world was kind of turned upside down recently in the UK with a recent Supreme Court decision in what's known as the Paccar Case. And the decision we're talking about today is one of the first decisions after that case, which tries to make sense of the whole situation and how it plays out. The case we're talking about is the Therium litigation funding and Bugsby property case. It's a decision of Mr. Justice Jacobs of the Commercial Court in England and Wales. The judgment was issued on the 20th of October 2023, so just over a month ago. And the neutral citation number is 2023 EWHC 2627 Comm. So where to start with this one, Calum?
Where to start, indeed. I think we need to start with a little bit of a summary of how we got here via Paccar. I suppose almost what the litigation funders do, what's a damages-based agreement, why are they an issue under English law, and how does this case then crop up? Probably the way I would start this one.
Yeah, I think that sounds good. Why don't you lead it off?
I guess if we start from the very start, there was a rule against an arrangement where somebody would take on a case without being paid for it in the promise of remuneration once the case was decided in favor of their client. And this was to kind of put people off effectively funding litigation, and to say, you know, we don't need people to be arguing everything. We don't want people to be arguing everything. So there was a kind of general ban at common law on these kinds of arrangements. And as the legal services world became more sophisticated, the legislation was brought into place to allow for damages-based agreements. There was a piece of legislation, the Courts and Legal Services Act 1990, which set out the sorts of situations in which people could offer damages-based agreements, i.e. legal services, in return for a promise of a share of the pie, if there was any pie at the end of the litigation.
Yeah, this was basically overturning the rule against champity, right? This old rule that if you're not interested in litigation, in the court action, you shouldn't be funding it, and that was really the old common law rule. It's only the party that has interest in those proceedings that should be funding the legal costs. And so, as we all know, there has been a kind of an explosion of litigation funding, which is the exact opposite of that, where a neutral third party is with deep pockets is funding the litigation, and they wouldn't naturally be concerned with that litigation. They weren't involved in the underlying dispute or know the parties. They're purely getting involved from a financial perspective and then taking some of the upside on a successful result. And if it doesn't go their way, they also have skin in the game and share that loss and basically make a loss on the investment that they made on the legal costs.
This act from 1990 is long. It deals with different types of arrangement, but one that it deals with are these damages-based arrangements or DBAs. And it had always been the conceived wisdom that litigation funders fell outside the scope of this act. What the act says effectively is that there is there are a number of points that need to be satisfied if you're going to have a damages-based arrangement. There's other legislation that sets out what these points are. It varies from case to case, or it varies from subject matter to subject matter. The type of case will mean that there's different requirements for a DBA to be lawful. But the litigation funders never previously were concerned about that, because they said, well, we're not offering the sort of service that falls within this DBA, this requirement to follow the rules of a DBA. And then Paccar came along. And in the case of Paccar, there was effectively a defense that was put forward. We don't need to go into the case in a huge amount of detail, but there's a lot of reading, online. If you search Paccar, Paccar, there's a lot of reading you can do on this case. It was very widely reported. But effectively, the defense was the way that this case is being funded is illegal, and therefore the case needs to be withdrawn. And the rationale was that the litigation funders, or the funders as they're known, were providing claims management services. And under Section 58AA of this 1990 Act, a damages-based agreement is an agreement, quoting here, between a person providing advocacy services, litigation services, or claims management services, and the recipient of those services, which goes on to say, which provides that you get a share of the pie. And the argument was litigation funders are providing claims management services. And this argument was rejected again, all the way through to the Supreme Court, where they turned around and said, actually, no, this is right. If you are a litigation funder, then you need to be following the rules on damages-based agreements. And in certain situations, that's impossible, because the rules say you cannot have damages-based agreement for this sort of case. And I think that was the situation in Paccar. Although by the time it got to the Supreme Court, it was just agreed if the funders fell within the the definition of claims of providing claims management services, then they would be providing a DBA that was unenforceable. That was agreed. The argument was simply on whether they fell within that definition of providing claims management services.
Yeah, and there's been this debate around the extent of Paccar and how far it reaches, whether it means that these success fee, share of recovery type DBAs that funders are entering into are enforceable across the board, whether Paccar is limited to a narrow subset of cases, whether it affects part of the agreements, whether it affects the whole agreements. And there's a big debate about it. There's also been some political interest in this and lobbying and potential changes to laws and what have you. So it's a whole kind of contentious, hotly argued area where there's a lot of debate at the moment. So if you're interested in litigation funding or want to know more about it, I highly suggest doing some more reading about it, getting into it and understanding it. Litigation funding is a really big part of top-end litigation, and not just top-end litigation, but that's mainly where it's seen. And it's a big industry. There are big sums of money involved and some big players that are in this world, and it has the potential to affect a lot of how litigation is funded and run.
And into that world, then, the Paccar decision. Let me just pull up the exact date. I don't have it to hand, but it was, it's a 2023 decision. I think it was, it was at some point earlier in the year. So it's a 2023 decision. So it's super recent, and into that area of kind of, I guess, confusion and uncertainty, trying to understand what this rule or what this new law means, comes this case where you have litigation funders, Therium litigation funding, obviously they're the funder, and Bugsby, and they're the recipients of the funding to go and prosecute their claim. Effectively, what happens is the funders have funded a claim. The claimant gets a settlement, but doesn't want to pay the funders. And the litigation and the litigation funders then want to bring a claim under their kind of funding agreement. The agreements is actually a series of agreements by which they agreed to provide the finance to Bugsby to run the claim, and those documents are all governed by arbitration. They're all subject to LCIA, and there's an arbitration that will continue. That will be ongoing on LCIA terms. But there's in the meantime, in order to make sure that they have something at the end of the road, they brought this Section 44 application before the High Court. Yeah,
exactly, and it's probably worth mentioning that Bugsby is a company that may be insolvent. It's not a viable company that's thriving by the sounds of it. I don't know anything about Bugsby, but from what I can work out on this decision, and the fund and some money has already gone to Bugsby of the settlement amount. Some of it's still held by their current lawyers, and I say current lawyers because I think they went through 3 or 4 law firms over the years. But the current solicitors hold a big chunk of the funds that came out of the settlement, and the funders are concerned that by the time the LCIA arbitration gets around to determining how much money should be paid to the funders, whether it should be paid to the funders, that the money will be dissipated and will go into Bugsby, maybe paid to other creditors and what have you. And it's important to note that the funders are arguing that they have a proprietary claim over the funds that have been paid out of the settlement, meaning that that Bugsby or solicitors on their behalf should be holding on to those funds on trust for the funders until such time as there is a final determination of how much they are to be paid. And this is one of the key issues in dispute here, but it's that proprietary element of the funding agreement, or the alleged proprietary element of the funding agreement, that really gets looked at here in close detail.
From Bugsby's perspective, if these agreements are all upheld, then they would get nothing. They would run this litigation all the way through, and they would end up with nothing. So when I read that part of the judgment, I had a little bit more sympathy for them to want to hang on to some of the benefit. But effectively, if enforceable, these litigation funding agreements would exhaust the entirety of the settlement.
Yeah, exactly. It's a good point to note commercially what's actually happening here, and this is something to keep in mind with litigation funding. It does come at a cost for the claimant, and the claimant may end up in a situation where they were not as successful as they were hoping to be, and the litigation funders, their costs, or the amount that they had they were to be paid under the funding agreement, actually exhaust the whole amount that was recovered by the claimant. And that, whether ultimately that is what happens here, that's the situation we're dealing with now. If the funders' full claims are to be paid out, Bugsby will end up with nothing. And so what the funders want is they want the status quo to be preserved. They want the money to be held, not vanish off into Bugsby's accounts and never to be seen again. But they want the money to be held on trust pending final determination of the amounts that the funders and others, as we could talk about this in lots of detail, but there are insurers that get involved, let's say, for the adverse cost risk that could arise if the claimants fail entirely in the proceedings and they have to pay money to the defendants. And you can take out insurance, and the funders tend to do this, that there will be insurance in that event, and there's a premium associated with paying for that insurance. So the insurers may get paid an amount out of the awarded sum too. And of course, the lawyers who have been running it, they'll have some claim typically over amounts that are due to be paid back from the settlement. So when you put in the funders, the lawyers, and the insurers, if you haven't been as successful as you wanted to be as a claimant, you can end up in a situation where you're getting nothing.
The situation here is that there's a pot of money. The pot of money is subject to an arbitration, or it's argued by one of the parties that pot of money is what they should be getting out of their arbitration. And they are then involving the court to preserve that pot of money under Section 44. So the case we discussed last time on the podcast was looking at a slightly creative use of Section 44, or effectively testing the limits of Section 44 and saying, can you use Section 44 effectively to prejudge the outcome of the arbitration? This is a much more conventional use of Section 44. This is simply this is the money that we're entitled to. We want to make sure it stays in place while we argue the toss in the arbitration. And that's quite important because it colors the way that the judge was looking at this question. And really, what it came down to when they were effectively seeking to preserve assets, and the judge was looking at the American Cyanamid test, and the key limb of that test that really this whole case turned on was whether there was a serious issue to be tried. And the litigation funders obviously said there was. They said there are all sorts of reasons why their agreement would still be able to remain in place, notwithstanding the decision in Paccar. And Bugsby Property, the party who are seeking to take the money and run, were effectively saying, no, there's no way you can go against Supreme Court authority on this point, and there's no serious issue to be tried. I suppose I say all that to make it clear that the burden for the funders here wasn't to win the case. The burden for the funders here was simply to say there was a case.
I think that's a really important point. And there's three elements to that test you talk about, whether an asset preservation order should be granted. And that's what we're dealing with in Section 44, the preservation of assets. Or evidence, but that's not the case here. And firstly, it was the Madoff Securities International and Raven case in 2011 that established that test that you're referring to does apply to asset preservation orders in support of proprietary claims. So we know that that test applies to what we're dealing with in this case. As you say, the main test, or the main element of that test that was in play in this decision was the serious issue to be tried element. There are two other elements to that test, and that is the balance of convenience is in favour of an injunction, and then thirdly, that it is just and convenient to make the order sought. Now, those two other elements were not really up for debate. Bugsby had effectively conceded those points and was relying primarily on the serious issue to be tried. And they were trying to say that in view of Paccar, there's a clear reason why the funders' claims would not succeed. There's not a serious issue in debate here or for trial, and it should be struck out. And that's difficult to do. Now, it is certainly possible in some cases, but that is the prism through which the judge here was looking at the matter. And so Mr. Justice Jacobs was very careful in the analysis, in setting out right at the start to say, that's the threshold that I'm looking at, serious issue to be tried, but also that if there's a big debate to be had, if there's multiple days of hearing, if there's very complicated arguments required, if it requires mature kind of discussion and argument, all the rest of it, that kind of suggests that there is a serious issue to be tried. It's the arguments that are clear cut, that just you can cut through a claim or part of a claim and say this just is not going to fly, where you can get through on this type of argument. And I think one of the issues here, and the court kind of hints at this actually, Calum, is that the Paccar case is very new and it's such a hot area. I actually looked up as you were talking. It was from July this year, 2023. So we're only a few months down the track, and the consequences of that Paccar decision are still being debated in lots of different forums. And I think given that this case goes to Paccar and how it's to be applied, now the court was somewhat reluctant to just come out and say, okay, that shuts all these arguments down. I think the judge was much more in favour of saying, well, as the ramifications of Paccar are playing out, we should be having the full debates. We should be maintaining the status quo on things like, assets and what have you, until such time as those debates can be had. And I think there was, obviously there's more to it than that, but that's kind of part of the rationale that I read that sits behind this decision.
Yeah, and it's an interesting decision for someone, for a judge at first instance to have to make, I suppose, because on the one hand, the Supreme Court authority is Supreme Court authority. And we can come on to why actually the Supreme Court authority is not on all fours with the situation in the Therium case. So the Paccar case is different to the Therium case in a couple of very important aspects. But even so, you effectively have a High Court judge who's sitting here and saying, well, yes, Paccar is settled law. Yes, it's Supreme Court law. However, this is a very new area of law. This is a decision that was overturned on appeal to the Supreme Court with dissent. Although it is the law and it stands as the law, this is an area where there's a lot of exploration left to be done, and therefore the issues to be tried are serious. Now, it also seemed as though Bugsby's approach to the claim was to say, that they needed a long period of time to really ventilate all of the interesting issues as to why there was no serious issue to be tried. And the judge kind of made a bit of a flippant remark about how, if you need 2 days of oral argument to persuade me that there's not a serious issue to be tried, then there probably is one, which I thought.
Yeah, I picked that up as well.
But I think the really interesting point on this one for me, and where it was made easy for the judge to say there was a serious issue to be tried. The way that the funding structure worked in this case was not purely on a damages-based agreement. There was a certain threshold, and I think it was a threshold somewhere north of 35 million, and the claim settled somewhere around 25 million. I don't know the exact numbers, but there they are in the judgment. But if the claim had got to that 35 million threshold, then anything on top of that would be subject to a percentage, which would be very much damages-based agreement style wording, style drafting. The exact concept of a DBA would fall neatly into, or that structure would fall neatly into the exact concept of a DBA. But actually, up to that point, the structure was slightly different, and it was all about returning the money that was put in by the funders with a multiplier. It was about payments out to the lawyers. The way that it was structured wasn't saying you get a percentage of the recovery. It was saying we get back what we put in plus extra. If you then go over a certain number, we also get a cut of whatever the excess is. And because they never got into that sort of classic DBA situation, effectively the recovery wasn't high enough to get them into that DBA type recovery. They said, well, actually, all of the bits in the payment waterfall before you get to that classic pure DBA situation fall outside this rule of DBAs. So we don't fall within the Courts and Legal Services Act 1990. Because we haven't agreed a DBA, at least for that part of the agreement.
If the agreement contains an element of a DBA, so if there's this element where the funder's payment is contingent on a percentage of a settlement sum or a judgment sum, does the fact that there's an element that could be described as a DBA render the whole agreement unenforceable, or is it a bit like an arbitration agreement in a main contract, as the analogy was used here by the funder's counsel, in that you can separate out the DBA element of the funding agreement and say that's unenforceable, but the rest of it, which was based on a return of cost paid with a multiplier, that is still enforceable, and that's not a DBA in nature, and it shouldn't be struck down on the basis of the Paccar decision. So it's this kind of, how do you characterize the agreement? And you can kind of see that there might be arguments both ways on that the level of the multiplier for the amount that was paid in, that could be commercially, that could have changed depending on how much percentage was put into the DBA component. The level at which the DBA component kicks in may have changed up or down, and that affects the multiplier on the amount that would be paid on the costs reimbursement side. So you can kind of see that trying to separate out just the DBA element of the agreement from the rest of it commercially may seem, it may not be reasonable to do. But similarly, the Act does deal with damages-based agreements, and that's what Paccar goes to. So why should the other elements of the retainer agreement, which are more traditional in nature, why should they be all shut down just because there is this component in there for the DBA? And I say all that because you can kind of see that there's a debate to be had there, right? And at this level, in this decision, what we're talking about is not what's ultimately going to be right on that question. It's, is there a serious issue to be tried? Is there a serious debate here to be had about whether the whole agreement should fall away in this case, or whether it should just be the DBA component of that agreement that falls away and the rest can remain in place? And, the court seemed pretty clear that there was a serious issue to be tried on this basis and that it should go to trial. And in the meantime, Section 44 should be used to keep the funds in place pending that final decision.
Yeah, and I think the funders also were helped with some case law from 2021, case law Zuberi and Lex versus Lex law, Zuberi and Lex law. And this case was referred to in the Paccar decision, but it wasn't overturned. It looked like it was so this is a Court of Appeal decision, and in this decision, is really on topic for the question of what's the nature of the agreement. This was looking at an agreement from a firm of solicitors, but the court considered how do you view what the DBA is, and the court effectively said what you've just said there, Luke. There are two ways of looking at it. One is that any agreement that has a component of uplift or of shared recovery, or share of the spoils, is a DBA, even if the rest of the retainer deals with other methods of payment. But the other way of looking at it is that it's a contract of retainer, which entitles a lawyer to a share of recoveries, but also other provisions which provide for payment on a different basis. I'm quoting from this Court of Appeal judgment now, or other terms which do not deal with payment at all. Only those provisions in the contract of retainer which deal with payment out of recoveries amount to the DBA. And the Court of Appeal went on to say that in their view, or at least in the majority's view, there were good reasons for preferring the latter approach, i.e., the DBA is only the bit that refers to a share of the spoils. And in that context, Therium could point to Court of Appeal authority that said, "Look, this is a point at least open for us to argue that the only bit of our funding agreement that Paccar can attack is the bit that applies to recoveries over whatever it was, 37 million, and not to the rest of it, which is where we're bringing our claim for payment." And again, we go back to the question the court has to answer, which is always important in these kind of injunctive reliefs or these applications before the courts. What do you actually have to prove to the court to get the thing you're asking for? And here, all the funders had to show was that they had a serious issue to be tried, and obviously with some helpful authority on side, with a highly kind of contested and complex Supreme Court decision, which kind of came as a bolt from the blue. There was so many different issues here that I think the court, was reasonably safe in saying this is a serious issue that has to be tried.
One of the arguments that was kind of focused on early was to show that the element of the funding agreement that related to the funder receiving a multiple of the costs was not, by its nature, a DBA, and that it was more a success fee or a contingent fee type arrangement. And there was an article that was referred to by the court here on the nature of funding. And so the way I thought it was quite clever, the way that the Funders Council kind of set this up was to say, well, there are parts of this funding agreement, the return of costs and the multiple of costs, that if there was no component of a DBA at all in that agreement, it would clearly not be a DBA. Just because it had the multiplier, that would not pull it within a DBA. And that was almost conceded, I think, by the other side. And then it goes on to argue, well, there is this additional component in this agreement, in this funding agreement, that is a DBA. And so you've got a composite type agreement. And so they kind of neatly set up this compartmentalized agreement. Whether that ultimately wins or not, it'll be interesting to follow it through if it ultimately runs and it's not settled out. But I thought the way that that was argued was quite neat. Did you want to say anything on the severance point or on quantum? I think that's really the critical part here. There was this debate on quantum, which I thought was at least worth touching on. But did you want to mention anything on the severance point?
Yeah, I think to be honest, the severance point we've kind of wrapped into what we've discussed. They could split out the two different parts of the agreement, or at least they could argue that they could split out the 2 points of the agreement. So given that time is not on our side, maybe we jump onto the quantum point.
Yeah, it was an interesting one. This was all about whether the entirety of the proceeds that had been paid to Bugsby itself and to its lawyers, whether all of it should be held on trust pending the final outcome of the case, or whether only the amount of Therium's claim should be held on trust pending the final decision. And at first glance, that seems a little bit odd. Well, like, why would Therium be arguing that the entire amount should be held on trust pending final resolution? But it goes to the wording in the Therium funding agreement. And it also goes to the fact that, and we haven't touched on this, but there was another funder involved in this matter, and an agreement was reached between Bugsby and that other funder as to how much it was going to get. And it didn't really feature in this matter at all. And what I can work out here is that Therium wanted to know that there wasn't going to be some shortfall at the end of the game, and that everything would be held status quo in place. Some monies wouldn't go to be preferred to the other funder or to someone else until such time as everything's resolved. And they had beneficial language in the funding agreement that cast a very wide net over any monies that are recovered, and what's the definition of claims proceeds. It was a very wide definition that captured anything coming in, and all of that, it argued, should be held on trust until the final determination as to who gets what. Again, the threshold here is not, is that right? The threshold here, is there a serious issue to be tried? And again, the court said, yes, all the money should be held in place and held on trust pending the final outcome.
To me, that was straightforwardly the sensible decision. Really, if you take into account just Therium's claim, sure, there's enough in the current solicitor's account to cover it, but Therium was one of many people seeking a recovery, and Therium's claim would be prejudiced by the other people who would have a better recovery than them, or would get paid out in priority to them. And it only made sense that the entirety of the pot was preserved, even the pot that had already been advanced out to Bugsby.
And Calum, I've got a practitioner's tip on this case, which I thought was. I found this really interesting, actually. So this argument on the quantum and how much money should be held on trust for the litigation funders pending the final outcome was not fully ventilated in the skeleton arguments and in written submissions prior to the hearing. And the judge noted that. He heard oral argument, Mr. Justice Jacobs, he heard oral argument on the quantum argument before him. And if I may say, I think being guided by the threshold in which he was assessing this interim measures question, and that is whether there was a serious issue to be tried, rather than just solely relying on the oral arguments, and there was no transcript taken here either, he asked the parties to set out after the hearing a summary of the arguments that they wanted to make on this quantum point. And I thought it was quite clever in a way, if I can say that, Calum, because what the judge was effectively doing was making the parties demonstrate how complicated some of these arguments were, and then receiving detailed summaries of the position that each party had on this quantum argument. Again, was really making the point, well, look, there's mature debate to be had on this. This is really more appropriate to be had at the trial rather than here at this interim step in the overall proceedings. I think the practitioner's tip there is always be thinking about what's the threshold that you're trying to get through when you're before the court. And then presentationally, how do you present those arguments in a way that demonstrates that you meet that threshold? And here, the more that Bugsby had to show that it was complicated, that it required detailed argument, the less likely they were to ultimately prevail on the relief they were seeking at this stage in the proceedings. So it's just, I don't know, I don't know whether you got a similar kind of thought along that, but it's this practitioner's tip about always, it's not just what you've got to say, it is also how it's presented. It is also a matter of persuasion. It is also getting the court on your side.
Yeah, and this goes as well to the request for a 2-day hearing. To be fair, I think that Bugsby and their lawyers were on hiding to nothing here. Really, it was a difficult case. The judge makes this point in the first 10 paragraphs. How can there not be a serious issue to be tried if you're asking me to set aside 2 days for an urgent hearing? It's from that point on, you knew the direction of travel, and as you say on the quantum points, the judge kind of had confirmed it before they'd even started. Really, go away and write down all the points that you're trying to argue here, because I'm confused. And the fact that maybe not I'm confused, but you've rushed through them quickly in oral argument, and I need to see them on paper to make proper sense of them. But then obviously, having seen them on paper, the judge is going to turn around and say, well, hang on a minute, there's arguments on both sides here. And there's therefore a serious issue to be tried.
They all require mature consideration and full argument, is one of the lines that the judge here has used. Well, look, I enjoyed that discussion, Calum. Thank you, everyone, for listening in, and I hope you've enjoyed it too and got something out of this discussion today. It's a really hot topic at the moment in English litigation arbitration with litigation funding. If you're interested in that as a commercial party, or as a funder, or as a litigator yourself, I encourage you to read to get more into it. If you'd like to discuss it with us, Calum and I, we're all over litigation funding and know all about it. So if you want to know how that might be used on your cases, what effect these recent decisions have had on some of the potential claims that you've got, then by all means get in touch with us, and we can help develop those discussions. Just a final last request, if you don't mind following, subscribing, clicking all those buttons that you do on podcasts to stay part of the group, and we very much appreciate it. It's how the podcast is growing. It helps get the word out there and develop it. So thank you very much for your patronage, and until next time, take care, everyone.
Thank you, everybody. Goodbye.